Hello, welcome to ABLA's latest in its series of webinars. Today the topic is parties, policies and problems. I'm very, very lucky today to have a guest from Melbourne, our star in our Melbourne office, Tamsin. Thank you and welcome.
Thanks so much, Julian.
We've got a really fun topic today.
We do, we're very lucky.
Parties, policies and problems. It's the Christmas season, or at least it's about to be. I think Christmas season starts when the Melbourne Cup is run, so we're a few weeks away from there.
2-3 weeks, yeah.
But there'll be plenty of planning of Christmas parties going on right now. And what we want to talk about is some cases where things have gone slightly wrong, some hints and tips for how you might structure your Christmas parties going forward, and really it's a real moving feast, some of the law in this area, so it's a really important year to get your Christmas party right. And hopefully we can go through that. We have, again, online questions, so please forward your questions through. We'll be getting to them at the end, but otherwise let's kick off.
Let's get going.
So here's a summary slide. What are we going to be talking about today? The first point we want to make, and we want everyone to go home with, is that Christmas party litigation can be really fun to discuss. I know you and I have had a great time discussing some of the cases involved that we're talking about today, and I hope we'll have a great time talking about them again right now. It's miserable to live Christmas party litigation. You do not want to be on this presentation being spoken about by Tamsin and I in the coming years as a Christmas party that went wrong. Try to avoid it at all costs. Secondly, Tamsin.
Well, the law is increasingly showing that there's a very little distinction between what happens at work and what happens in people's private lives. And they're really saying that there's a lot of sufficient connection between party type conduct that the employer might have sanctioned and then things that might have happened after that event. Third one, Julian?
So the work social misbehaviour, what happens outside the workplace, that needs to be investigated as any other misconduct would be. Merely because it happens at a Christmas party or in some kind of other social event doesn't necessarily mean it can just be ignored or swept under the carpet. Identifying what can be left in Vegas, however, is really difficult, and I think it's going to be increasingly difficult to leave anything in Vegas, but we're going to get to that. Absolutely.
And that probably is a nice segue to the next point, which is that the world and the law in this space is really moving very fast. I think, as we'll talk about next, and is the next point, the positive duty makes things very difficult for employers, and it's really culture setting. I think that's what we're seeing. We're seeing the law push what the expectation is both amongst your employees, but also within your workplace. And that is a really nice segue to the fifth point as well. This positive duty, hopefully you've heard about it before, but it is on the horizon. And, you know, I'm a bit of a betting person, Julian, and if I was putting my money on it, I would say it will be the law before Christmas. It will be the law at your Christmas party.
Tamsin, I think you told me this morning that you only bet to make money.
Yes.
So if you're smart out there, you'll put your money on that as well. Number 6, and this is probably being yelled at the screen as people get increasingly furious at these two wowzer party-pooping lawyers who are telling you not to do anything and that the fun is over. Yes, we are adults. I can hear you. I get it. We're adults, but we're in a workplace. And increasingly, both for various reasons, both the law and also a bit of a generational shift, as inevitably generations do shift, expectations will be different, and I think the workplace needs to catch up to that. Lastly, and this I guess will run through everything we talk about, inevitably, because we're lawyers, we're talking about risk. We're talking about the risks that employers take, the risks that employees take when they socially interact, when they try and put on a good evening or a good weekend for their employees to reward them, sometimes in a Christmas party sense, sometimes in a social sense. We're talking about risk, taking those small risks. Now, risks are impossible to eliminate. There's a asterisk on impossible because you could actually eliminate risks.
Don't have a Christmas party.
Don't have a Christmas party, Tamsin Lawrence says. I'm pro-Christmas party, but that's the only way you can really eliminate these kinds of risks. I don't want to do that. Most people watching don't want to do that. But you need to learn how to mitigate them, and increasingly, as we will see, Tamsin, the law will expect you and in fact require you to mitigate them.
Yeah, absolutely.
So let's get into it. So work versus play, where does the workplace stop? And this, I think, is the question everyone asks. Well, we're not really at work, are we? This happened, but it's not actually a workplace issue. Now, inevitably, it's fact dependent. The reason why this area is so fun, engaging, and we enjoy it so much is that you get to the nitty-gritty of the detail of party planning, of how things go down, how much people drink, what they do, and how they become unstuck, usually. It is arguably expanding, and we'll talk to the line of cases that are coming down through the commission. But what is required is a requisite connection to work. Now, shifting away from Christmas parties slightly, we have to mention Rose and Telstra as the first sort of bedrock.
It's juicy.
It's juicy, and it's one of those seminal cases that is mentioned in basically every decision about the distinction between work life and private life. Again, I told everyone that we enjoyed the facts of these cases. So this is from 1998, which is, for some, a long time ago. It was two Telstra employees, one of them who was from Tamworth, who got sent to Armidale on a work trip. He was provided a travel allowance, and it happened that he ended up in a hotel room with another Telstra employee. Technically, I guess the hotel room was paid for by the employer. There were some disagreements, you might say, during the evening, and when he returned to the hotel room with his hotel room buddy, his hotel room buddy had sort of moved the furniture or to the extremities of the hotel room to create what was in effect a boxing ring, and challenged Mr. Rose to a fight. That fight commenced with one of the workers putting their hand through the window, taking a shard of glass, and then stabbing Mr. Rose in the chest. Now, that employee went to jail, but Mr. Mitchell, exactly right, but Mr. Rose lost his employment because of his involvement in this really serious fracas. Now, that decision essentially examined, well, was that behaviour in work, and was his conduct during that incident, that fracas, that melee, was that sufficient to justify the termination of his employment? Now, it was found that it wasn't in work for a number of reasons. Now, again, no, it's a very old case. He wasn't in uniform. He wasn't on call. I mean, he genuinely was in a hotel room staying at his leisure, although he was in Armidale only for work-related reasons. That being the case, Justice Ross, or Vice President Ross, as he then was, decided that where the conduct was found to be outside of work, it still could justify termination, but you need to jump through some pretty serious hoops. Does the conduct cause serious damage to the employment relationship? Does it damage the employee's reputation, interest? And is it incompatible with the employee's duty as an employee? Basically, in a really short form, if someone's doing something outside of their work, it has to be so serious that it basically means they can't be an employee anymore. Now, in that case, yes, the court listing made the papers. Yes, everyone at the various country town Telstra work locations knew about it, but it ultimately didn't particularly damage Telstra's interests, and so ultimately it was determined that Mr. Rose was unfairly dismissed.
Interesting case. Do you think it would be decided the same way now?
Yeah, it's a really good question. My take is, because the media in 2022 is very different to what it was in 1998, the likelihood that this would not be in the papers, would not be all over social media, wouldn't be on BuzzFeed or whatever.
There'd be a video, no doubt, of the boxing ring.
What an outstanding observation that is. I think it's probably unlikely. I think you probably can't get away with this. Now, remember, Mr. Rose was stabbed. He wasn't the stabber. So I understand that. Very much he is a victim in all of this, but he has gone down definitely in history as the main case in the private versus workplace idea and distinction. Let's jump forward a few years, and we will get to Christmas, and I'm just going to give a bit of a language warning here. If you've got sensitive ears, perhaps you just close them. Mr. Keenan was an employee of Leighton Boral Amy Venture. There was a Christmas party, and sometimes the facts are really, really important in cases like this, and this is one of those ones. We have a double level building, and downstairs there is a Christmas party, and upstairs there's a bar. Downstairs, the relevant facts are it was unlimited drinks, and Mr. Keenan didn't quite drink an unlimited amount, but he certainly gave that a go and drunk a lot to the point he was intoxicated. During the downstairs Christmas party, he told a board member, of all people, to fuck off, mate. He asked another employee, who the fuck are you? What do you do? And then after having a conversation with one female employee about her children, he segued straight into, I wanted to ask for your number, but I didn't want to be rejected. Now, the Christmas party ends and everyone makes their way upstairs to the bar. This is where it really starts to unravel. Mr. Keenan attempts to touch a dimple on another employee's chin. He advises another employee that I used to think you were a stuck-up bitch, but Ryan says you're all right. If Ryan likes you, you must be okay. He grabbed the face of another employee and with no warning whatsoever, kissed her on the mouth. He advised another employee that his mission tonight was to find out what colour her knickers were. She replied, they are white, touch my skirt and I'll kill you. This is very serious behaviour and he was dismissed. Now, what I don't want to talk about is some of the procedural problems in the investigation and how it was put, because as everyone on the webinar will know, people have a right to substantive fairness, but also procedural fairness. We won't go into the nitty-gritty of why it might have been procedurally unfair, but what we will talk about is the fact that this upstairs-downstairs distinction was very important in 2015. Now, the employer, it was found, was not able to rely on all the shenanigans, all the misbehaviour, quite frankly, all the serious misconduct which occurred upstairs, because the upstairs party was not organised, authorised, proposed or induced by the employer, and the employer would not have been otherwise vicariously liable for it. Now, all that left against Mr. Keenan was the downstairs behaviour.
Bit of swearing. Rudeness. Who knows, maybe it might be determined even on the downstairs behaviour differently today. But nonetheless, it was determined that the dismissal was unfair and Mr. Keenan won his case. I must say on this one, Julian, it's going to be very interesting because a little while later we're going to discuss Westpac, and in a similar circumstance they gave quite a bit of alcohol to their staff, and then some similar moving on from the venue occurrences happened. And just one to kind of signpost for people to see how from 2015 to this decision in 2022, how fast the Commission has moved to saying that employers have far more of an obligation to make sure this kind of conduct doesn't occur, and that this kind of conduct might actually be still considered to be occurring in the workplace.
Yeah, it's a great point. I mean, the other thing that I should mention is that in this case, the employer was criticised for not having any sort of supervisory presence at all in the Christmas party, no designated partiers, no management checking on consumption of alcohol. So even though the case didn't quite go the employer's, didn't go the employer's way, the other aspect of it was even in the party, even in 2015, I can say personally feels a long time ago. Even in 2015, there was criticism saying, well, there was no real risk mitigation going on here. Interesting case, but we move on.
Keep going.
So Drake and Bird and BHP. This is again 4 years on. We've jumped ahead, and this is quite interesting because it probably provides a bit of a contrast to the Keenan case. So Mr. Drake and Mr. Bird attended the Goonyella Riverside Mine Pre-Strip Department Sea Crew Christmas party at Miranda Bowls Club, and they had a fight. Now, one of the defences that they used in this case was to say we didn't actually know it was a Christmas party that organised by work, because all it was we usually would have sort of weekend or maybe monthly drinks, and we just thought that this was just a slightly bigger one. Now, the reality was that 90 people attended. I don't know how your Friday night drinks go, Tamsin, but
not quite that big.
No, 89 people do not come to mind. 60 of those were employees. It wasn't swallowed that it wasn't a work event and was privately organised. I've just extracted the thing I like about this case, or the words I like. I'm also of the view that the fact 90 people, including 60 employees, were gathered in one venue with a common purpose of celebrating Christmas is sufficient to establish that the event was work-related. Those employees should not assume that their conduct will be considered out-of-hours conduct, and that is not related to work to which the employer policies do not apply. We see the P word there, policies. That's even in the title of this presentation. It's something that we shouldn't underestimate. Managing your employees' expectations, directing your employees what they're meant to do, and particularly what they shouldn't do, will be critical in any unfair dismissal that is ever run against you.
And training them in the policies. Precisely,
and we will get to that. If employees do not have a very clear understanding, and if you have not told an employee a very clear understanding of what is expected of them and what they should and shouldn't do, it's difficult to later rely on the fact that you're going to dismiss them for doing the wrong thing.
Even where it might seem like, they should know where the line is.
Exactly right. The first question often asked in a Fair Work Commission case is, well, what's the policy, and can you prove that the employee was ever given it, was ever trained in it? When was the last time it was issued to them? So, interesting case, probably creates a bit of a contrast between the upstairs, downstairs Mr. Keenan case, because in this one, it was enough that there was a lot of employees there. It was a Christmassy thing, and you can't be fighting in that kind of context, or in any really. Here's a real fresh one.
This is a real doozy.
It's a real doozy. It's unfortunate in a way, because this is a really generous employer. This is a hairdresser who, South Australian case, who, as a tradition, puts on a weekend away for their employees. As it happens, what they do is close on Saturday, which is quite a big deal for a hairdresser to do. So they forego all that income. They pay for accommodation, a Saturday night dinner, Saturday night accommodation, and then a Sunday breakfast. It's a big thing at this employer. Everyone builds it up. The expectation is that everyone goes. Interestingly, the employees don't get paid regardless of whether they go or don't go. So they do forego the income of not working on the Saturday. But this is a big thing. It's a big tradition. Now, I've given you the background, and I think the best way of doing this is to sort of just jump into this paragraph 116, which is the best part of the case. We have employees who go out for dinner, then they have drinks at the pool, and then there is a spa bath organised with some employees going to the spa bath. Interestingly, like the employer, the actual person, twice during the course of this spa bath came from downstairs upstairs to tell their employees to stop splashing. So they're aware that they're in this spa bath, they're aware that there's some hijinks in chewing. And obviously these employees, after a long lunch, after drinks at the pool, they were very amply
having a good time.
Yes, that's a lovely way to put it. So in determining whether this incident, because this very unfortunate employee broke their hip, in determining whether this incident was a compensable injury, the South Australian Tribunal had to determine whether this was all on work time. Now, what that tribunal determined was that the accommodation was chosen by the employer. It had a swimming pool and a spa bath. Everyone took swimwear to knowing that they would use the swimming pool and the spa bath. It was encouraged from the employees that attendees should be able to let their hair down. To that end, ample alcohol was provided. Adding a male stripper to the pleasant accommodation amenities, alcohol reinforced the message that employees were able to let their hair down. And spa bath ensues, for some reason, only known to themselves perhaps, the members in the spa bath were splashing, put water on the floor, then put liquid soap onto the bathroom floor, and then removed their swimming tops and started sliding across the floor. Now, that's not work behaviour, clearly.
No.
But what was found in this case is that the fact that the employee had facilitated this, had encouraged the letting of the hair down. Mm-hmm. Now, clearly, removing swimming tops and sliding across the floor after putting liquid soap on the floor is not something the employer would have ever suggested, and is clearly not within the scope of those employees' employment duties. No. But if you organise a weekend away, if you provide unlimited alcohol with a spa bath, and to be fair, if you are actually involved and are aware that employees in the spa bath are severely intoxicated, it's not entirely surprising that the injury that resulted from what seems like a very enjoyable scene was actually found to be compensable by the employer.
Maybe on that one, it's a good reminder as well that there have been other very similar cases that have found if you have a Christmas party at your home and someone is injured. There's a famous case out of New South Wales, only recent, Richard Panels, where somebody had a golf cart at their house. They didn't ask people to get on the golf cart, but they had their Christmas party that kind of ventured back to their house, and someone got very, very injured on that golf cart to the extent they couldn't even give evidence in the hearing about it. But it was found that because there was a golf cart that was at that house, it was owned by the boss at the time, that he was found to be liable. Even though he said to them, please don't get on the golf cart, don't drive the golf cart, he went to bed. They subsequently took it and somebody got injured. I think it's just that reminder that if it kind of happens within your purview, even if you're not sanctioning people splashing in the spa or putting down the soap or getting on the golf cart, it's likely still going to be your responsibility.
Again, this comes back to these are the risks that you take. Now, a weekend away, it's potentially great. It's massive cultural benefit for the team, close connections. Depending on who your boss is, I guess, the Christmas party at the boss's house with the pool and whatever it is potentially fantastic, far more fun, far more, the value that you might be able to derive from that from a cultural perspective might be quite large. From a risk perspective, you really are taking on considerable risk to do that. There are reasons why people want to undertake these kind of things in a controlled environment.
Absolutely.
And the boss's house, you wouldn't call that a controlled environment unless you've done a risk assessment, but maybe we might get to that.
We'll come back to it.
We've gone on a journey, Tamsin, from 1998 to 2022. The world has changed in that time. Tell us about the world as you see it right now.
Well, perhaps if we kind of flick back again, I always think back to Chrissy Fraser-Kirk and David Jones, and remember that's, I suppose, the seminal case of bad behaviour in the workplace. And that was only 2010. And I think how far we've come, we now have, as you said, the Me Too movement. We've had the Harvey Weinstein scandal. We've had the Respect at Work report. We've had huge, big, very well-known employers. Parliament House has been a place of an incident. We know that the High Court's had issues. The Victorian Supreme Court's had issues. And that's only 12 years on. And we've really seen that the expectation on employers to have done more than just hand someone a policy or do a bit of training has just continued to grow. And I think we will in a little bit, perhaps on the next slide, get to the whole positive duty and what's coming. But there's this real expectation of risk management. As you said, it's no longer good enough to just deal with the incident after it occurs. There's this idea that employers have this expectation and this obligation to, frankly, stop stuff before it happens.
And those sort of generational shifts are inevitable. I mean, just as many of us, including myself, would have started a work environment where people used to sort of wistfully look into the distance and say, in the 80s, this used to happen. People coming into the workplace now are saying, I can't believe this happened in the 2010s.
Exactly.
Can't believe it. And it really is important to think about. It's not something you can ignore. The reality of the way businesses are structured is that the older people are in management, more senior people are in management. It's really important to understand that your grasp of the world, your grasp of expectations, your grasp of what people maybe should know needs to be calibrated against that. Your younger staff will have very different expectations. They might have very different life experience. They might have very different thresholds for all kinds of things. You need to think about those people before you organise events, before keep on saying it, before you take these risks to have these social events. And the other thing, we live in an incredibly informed age. People have information about, steps they can take to address these types of things. There's a lot of support going. So the likelihood that people won't just sort of say, oh, that was a bit weird, or I felt a bit awkward about that, or that was unfortunate, and just let it go is probably less.
The victim blaming kind of generation, I think, is over.
Yeah, well said.
So we come to the new state of the law, or where it's coming, and as I foreshadowed earlier, I would predict this is probably going to be in place before December. And I think, as you might have seen through these cases, that from 2015 to now, there was this sense that perhaps the law was, and court cases and decisions were taking a little while to catch up to society's expectations. But with the new positive duty that's coming and the new work health and safety obligations, particularly around psychosocial risk, we're really seeing, I think, the law push the agenda and push the cultural and the societal expectation upon business and kind of employees more generally.
Tamsin, can you explain what the positive duty is?
Yeah, absolutely. So the positive duty is a duty that is placed on every employer to take all reasonable and proportionate steps to eliminate any risks that might occur in the workplace with regards to, frankly, sexual harassment, sex discrimination and victimisation in particular. And there's also added to that, in this same piece of legislation, a new offence that's coming about creating a hostile workplace environment. So that might be one that is seen to be overly sexually charged, or one where, casual jokes are just bandied around all the time. And that's one where you don't actually need anybody to have made a workplace complaint about the conduct. So as we can see, it's pushing the cultural expectation. It's saying even if someone's not complaining about this behaviour, even if you have no one's reported anything, there's this expectation that you've still taken all steps. And that's the difference between the way the law currently works. So currently, when it comes to vicarious liability, employers have the ability to say, well, I'm not vicariously liable because I took all reasonable steps to prevent this occurring. And normally that's, I gave them a policy, I did training with people.
I sent them a backside covering email before the event, and that's enough.
I whipped it out 5 minutes before the party.
Yeah.
This new law is saying, actually, that's not sufficient. You have a duty to take all reasonable and proportionate steps to eliminate. So that means that you could have the regulator come after you even when you have no complaint made, simply on the basis that you haven't taken reasonable and proportionate steps to eliminate. And we've seen that recently in Victoria. Victoria is the only state that currently already has this positive duty in its law, and that same positive duty is being replicated around the country. And Baker's Delight recently got investigated essentially almost as a kind of lesson, I think, for most employers. And in that case, they had no complaints against them. But the regulator said, no, you're not meeting the expectations of the steps you should have taken. For example, they were doing a lot of training online. They weren't doing in-person training for their managers. And the regulator said, no, in order to meet the positive duty for certain people, you need to be doing online training. And they're currently under a compliance deed and have 12 months to improve their behaviour. And similarly to that second point, we are seeing that this work health and safety kind of lens being put over things, that proactive, you need to really be doing a risk assessment, considering what controls you can put in place. It's no longer acceptable to just say, well, I didn't really think that person was going to get drunk and do bad things or slide across the floor or get out the golf cart. There's this expectation that you might needed to have considered the venue that you've chosen. Maybe don't have a spa bath or don't have a party at your boss's house.
It's interesting because on those 2 points, there really are two types of things that go wrong at a Christmas party. There is the sexual harassment, sexual assault type of behaviour, and then there's the assault type of behaviour. They're really the things that they're the main two ones. And if you think about it, either because of the positive duty in relation to the sexual harassment, sex-based discrimination aspect, or just your stock standard, everyone knows about it, work health and safety obligations to avoid hazards to people, there really is an onus on employers to actually do something to prevent this. And as you say, the idea that you can say, well, I'm going to trust my employees that they'll stay loyal to the cause, no one's going to make a complaint, everyone's good, and so essentially we can
nothing to see here,
and we can take some pretty big risks in how we have fun, how we do these things. That doesn't really work anymore.
Well, it won't from December.
It won't for December, and you might be sad at that. I think that would be reasonable, but that's just the way it has gone. And I think employers need to accept that and understand this.
So when should you investigate staff party behaviour? Does what happens in Vegas stay in Vegas?
It's a great question. So let's assume something's gone wrong. And to be fair, there's always risk taken at Christmas parties. I often wake up after a work social event and think, that was really fun. That was very interesting, but people were relaxed, and perhaps people, occasionally people can be slightly more festive than they would be in the work environment. The first question you would have to ask yourself is, has there been any complaint? Now, merely because there's no complaint
doesn't cut the mustard anymore.
It's not going to cut the mustard. In thinking about the types of issues that might arise, one of the things that's really important to realise is there any safety risk, ongoing safety risk? Because if there is any ongoing safety risk, it's really, really important to identify and neutralise, mitigate that safety risk. So if there's been an incident between two people and there's any ongoing safety risk, you really do need to do something to mitigate the risk that those people are going to have to potentially interact, or you need to make sure that's okay, because the tail of some of these incidents and issues can go much further than
just the party.
December 19 or whenever yours is. Policy and cultural alignment, you've got to think about, well, what happened consistent with our culture, consistent with our policy? But let's get to the hard law, Tamsin. I mean, at least in the old days, you might say, oh, we just might chalk it up to a bit of fun, a bit of looseness. Let's just leave it be.
Yeah.
Let's leave the sleeping dogs lie.
Or they told me, but they don't want to make it formal. I don't want to make a formal complaint.
Exactly. Is that going to work?
Not anymore. Basically, once you're on notice that something's either happened that is not meeting your expectations or has crossed the line, you are under obligation and duty to do something about it, to take steps to make sure it doesn't occur in the future, or to prevent any kind of repercussions, as you said, that might arise from that, such as employees still working together in the same environment. So I think often people, almost because these topics are quite difficult, as you said at the start, these are the most difficult things to potentially you will ever deal with. Often we might look for ways out of it, such as, or the person doesn't want it to be formal, they don't want to put it in writing, or, frankly, I've handballed this one to the police if it does involve physical violence, or we've already terminated the person, so they're gone, or they resigned, so I don't have to do anything. And I think the real message is for people to remember that if any of those things happen, don't stop. Yep. You still have something to do. And that might mean that you can't conduct a formal investigation between the people, because maybe some of them are gone, but that doesn't mean you can't do anything. Perhaps you do need to do a review, an update of training with your employees. Maybe your policy isn't meeting expectations. Maybe you didn't do an adequate risk assessment for the venue. Was there a spa bath? I keep coming back to that. But there are definitely things you can always do. And so if you're doing nothing, you're probably doing the wrong thing.
You're absolutely right, Tamsin. I mean, the other way of looking at this is you can look at this type of stuff as a backside covering exercise and we just need to tick some boxes. Or you can think, what was it about our setup of the last event that created, facilitated, allowed this thing to happen? Now, I must say it's much easier when you're talking about serious incidents like fights, complaints that are obviously grounded in real problematic behaviour. It's harder. Someone, potentially, and we talked about the prospect of people not making complaints. I mean, if someone makes an off-colour joke in a toast or a speech in a Christmas party and everyone laughs, do you do anything? Now, it's a judgment call, and strict compliance with the law says you probably think about what you need to do, but it's getting increasingly difficult to, at a later date, say, oh well, we just let that go. Because people can complain later. Obviously, investigations can occur later, and realistically, if you've created an event which something not quite right happens, the chances that something will not quite right happen at a later event is pretty high as well.
And it doesn't need to be always, as you say, if someone makes an inappropriate comment or joke or says something in the speech, it doesn't necessarily need to always be one-on-one with that person. I think there's sometimes this expectation that you've got to sit them down and have a chat about it. It might not be that. It might be retraining everyone or reminding everyone about it's important to consider the jokes you make in the workplace. There's a lot more, I suppose, subtle cultural things that you can do that might address that behaviour occurring in the future, that might not necessarily be investigating that person and exactly that joke that they made.
So you mentioned investigating that person. Again, relatively new case. There is a workplace, and the boss has the party at their house, and he has the party for his female employees. I should say female employees because all of his employees were young females. Those employees were asked during the Christmas party, "Are you enjoying the Christmas party?" And what did they say, Tamsin?
I said there were 3 issues that were causing them a little bit of concern. One, that they thought that, well, they'd heard rumours actually that the party was being hosted at this Airbnb house that had a pool because Mr. Shen, who was the boss, apparently had taken a liking to his new EA type assistant he had, and he was hoping for her to, I think, dance around, maybe strip by the pool for him was, I think, the terminology they used. They also alluded to the fact that they'd heard rumours that he was having an affair with her, and also that he'd been brainwashing some other staff members as well.
Quite serious stuff, that. He didn't like hearing those rumours, and he wanted to know the source of those rumours. So how did he try and investigate this, at first at least? Well,
as you would. He gets all of the employees around and he asks for a show of hands as to who might have been spreading these rumours. His request for a show of hands was unsuccessful, as you can imagine. No one said that they were responsible.
Orkies.
So he thought next port of call was to do a secret ballot, to ballot the employees as to who had been spreading the rumour. And unfortunately, 3 people wrote down the name of Miss Yang, who he then said, well, it's you. You're the person who's been spreading the rumours. I've got 3 positive responses to my secret ballot.
Now, I'm sure we have some viewers who have undertaken investigation training, maybe given by me, and Tamsin, perhaps yourself. This is not a technique that I would advise the anonymous ballot to determine guilt of employees. We put it up there as a bit of a laugh, but also it's important to remember that the general vibe of Christmassy, this is all fun, we're all having a great time by the pool, it doesn't translate to defensible investigative processes. If anything, if you want to do anything arising from a Christmas party aftermath, you need to take off the Hawaiian shirt and the Santa cap and just put on HR or legal hat again and do a proper process, because if someone brings an unfair dismissal, you'll be expected to have undertaken a full investigation of regardless of what it is. Sometimes these investigations are really like awkward timing-wise, because sometimes they're in January and people are away. They take longer. Unfortunately, that's how it goes.
Perhaps that's a good question, though. If there is inappropriate conduct occurring at the Christmas party, do you step in there to kind of stop that behaviour? Do you send someone home? Do you start investigating then and there, taking some snaps? What's the...
I think you certainly do, and we can jump to this right away. One of the expectations that people and the Commission courts will have is that you have some kind of organised way of keeping a lid on things at your Christmas party, and that might be a designated person to stay relatively sober and to be on the lookout for any danger spots. That may, and it really should be, the high level of management being with the authority to pull someone aside and say, actually, you've had too much, maybe it's time to go home. That could be the best advice, the best favour that person ever does to the party animal, because a lot of this stuff, it's risk mitigation. A lot of this stuff is stopping these things from happening instead of letting them unfold, sort of, with your hands over your eyes thinking, I can't believe I'm watching this car crash, because the car crash happens and then the cleanup, as we say, it's very unpleasant. It's very, very unpleasant. We've got a poll. So given we've just told everyone to never stop, always investigating.
Might have given the game away.
Please, can we? I'm not precisely sure how it works on your screen, but I think you'll be asked at the moment whether you can get an answer to this. Do you investigate informal complaints? And I'll just monitor the results. we've got a very strong, we're getting some good yeses in. We're getting very good yeses in. There is I think it's mainly because they're trying to look good in front of you.
Well, at least they've learned something.
Exactly. Again, it's a bit of a judgment call, and all of these things are risk. You can't, as I've told this to many people many times, you can't investigate everything in the most formal way every time, but there is certainly a window, an increasing window, that you need to do proper processes to deal with these kind of things.
Yeah, and just because someone won't put something in writing doesn't mean they haven't made a complaint. I often find that people say, well, they didn't put in writing, I asked them to. The law has this expectation, as I said earlier, once you're on notice, once you've become aware, whether that be someone telling you or kind of texting you or whatever it might be, once you become aware, that burden has passed to you to take action to mitigate whatever risks might have arisen from that and to prevent it occurring again in the future.
Investigation isn't always a full form, getting in a hired gun to interview everyone and produce a 100-page investigation document. Investigations can be informal, they can be relatively done with some discretion, let's say that.
Of course.
But you would be foolish, I think, to just simply say, well, we don't need to do that because it's an informal complaint.
Yeah, and it could be as simple as just sending an email back around to everyone and reminding them of what the expectation is, or perhaps thinking next Christmas party, we've got to do a better job of pre-warning people and making better choices. That could be the lesson you learn from the informal investigation that takes place. 3
hours of unlimited alcohol is too long.
Yeah, you might 2.5 next year.
Yeah, excellent. The party's over. Is it over?
Well, according to this case, it's definitely over for Westpac. This is one of a Mr. John Kernan, who unfortunately made an unfair dismissal claim. He was unsuccessful, but it all came about because he had attended what Westpac termed to be a sundowner. So Westpac was hosting this conference type event, and then they held a networking event that was not compulsory, I must say, but it was between 4:30 and 6:30 at a sports bar. And they provided alcohol, and after that event, some people kicked on and they stayed at the bar, and then they did venture to a casino afterwards. But at the bar, at least, Mr. Kernan engaged in some inappropriate behaviour, some sexual harassment type touching of some juniors, and there was a question of whether that conduct occurred at work or whether it occurred afterwards. And the Commission really said, and I think this is what I was alluding to at the very start, and we said that the world's changed a lot since the upstairs downstairs case and since the stabbing in the hotel room,
the boxing ring.
the boxing ring, that now the Commission is so much more willing to say there's a sufficient connection. But I think there's some really good lessons for employers out of this case, because obviously Westpac, it's the high watermark, but the Commission was incredibly critical of the way that Westpac had held this so-called networking event, and it was incredibly judgmental of its venue. I think perhaps a little bit unfairly, I must say, but they did say it was at a sports bar and that is a venue that perhaps was not conducive to making women feel very safe, and migrants and people who apparently follow certain religions. They were also very critical of the 2-hour unlimited alcohol. And I think a lot of people saw this case and said, well, whoa, can I not serve alcohol anymore? I think that's perhaps not the lesson. It's perhaps the second and third point that comes out of it, where they say there was not proper supervision. And that's what you were saying earlier. Was someone designated to watch over this event? Was someone there to say, hey, buddy, you've had a bit too much to drink. You're getting a little close to the junior. Time to go home? No. There was no transport provided to people to get home. It was just kind of like you do your own thing after the networking event. And that's a big kind of thing I think that employers can do that's really simple and easy to make sure that you're providing the transport for people to get home, not done by Westpac. And they almost, I think the Commission was saying, alluded to sanctioning kind of the after event that occurred, because everything was a little bit informal. It was, it was a sundowner. It kind of seemed fun. And a lot of people had stayed on from one venue to the next. And so I think this one is a really good, although it's not a Christmas party, it's a really good case to understand what the high water expectation is, particularly for larger employers. I think for the smaller ones, some of these things might be a little bit out of reach.
I think that's right, Tamsin. I like one of the questions posed halfway down this paragraph. If alcohol is a necessary element of the event, that is a question not often asked.
No.
Often it is just assumed, and in fact, the point of some of these events is to consume alcohol. employers should, again, think about the fact that all of these things involve taking a risk. There are many different ways that you can have work-related events that don't put alcohol as the primary and sole focus for it. And I won't necessarily agree with the idea that, you know, having it at a sports bar will be alienating to women and migrants or different religions. But I would say clearly there are people who do not partake in or do not elevate alcohol to the point of a hobby. It really is necessary to understand who you is in your workplace and cater an event that makes them feel comfortable, and the most important thing, makes them feel safe. So we're back on to risk. We've spoken a bit about this. Tamsin, do you want to talk through, I mean, really, this is about planning, isn't it?
It is. It's absolutely, this is all about the risk mitigation. So I think that's the difficult thing. I think you often think Christmas party, how can I really mitigate the risk any further than, you know, reminding everyone don't do anything naughty? Well, the understanding now is that you can. Think about your venue choice. Are you picking somewhere like Westpac that's considered to be a venue that might ooze a little bit too much fun or might not be comfortable for some people? Have you made sure that the length of time that you're providing free alcohol is reasonable? And maybe also think in that respect, are you serving food at the same time? Are you providing free spirits, for example, or are you just doing wine and beer? All of these things are things that if something does go awry, are going to be taken into consideration.
The timing is interesting because often these parties or these events are tacked on to other work-related events. If you have the work-related event and then have too long a time between that and the party, people go to the prees, go too hard at the prees, and then the party's a mess. Equally, if you have an event which is structured so that there is an obvious after party, it is obvious that people are going to go to a particular venue en masse as a group, you really are running a risk that that after party will be deemed to be work-related. Everyone will be there. There is a way you can structure this without necessarily being a party pooper or a wowser, which will ensure that the party is really at the party and that the expectation and the direction would be, well, that's when the party ends. It's really, really clear that that's when the party ends. Providing accommodation, again, is good from a safety perspective, brings its own risks, and you need to really think about providing accommodation to your employees in scenarios where they're going to be drinking and they're all going to be together. We've got many cases which we didn't actually go into, very famous cases about what happens when you give employees alcohol and accommodation. Responsible service of alcohol, it's a no-brainer. Themes and activities, I put in inverted commas, I mean, they need to be workplace appropriate. It is fun. It's meant to be fun. People build it up for a long time, Christmas parties. You do not want to be fostering, as uncool, as unfun, as granddad as this sounds, you do not want to be fostering an environment where people will take it too far, causing offence, because it's a complicated world and people have different views. Yeah,
strippers no longer acceptable, I would say.
Yes, if they ever were. So policies, and we've got a few questions on policies. Tamsin, this is one of your pet topics. You don't like an employer just issuing some policies to an employee on their commencement and then just forgetting about it, do you?
It is the biggest red flag to issues and to liability. One of the recent cases actually that happened earlier this year was a hairdresser who did exactly that. He had a big, good, solid policy that he whacked and given around to staff at a kind of morning tea that took place, and he thought that he would effectively tick and flick and I'm done, I've given them the policy, and he was found to be vicariously liable. The Commission said, well, that's not taking all reasonable steps to prevent. Just having the policy is not enough. Your employees need to be aware of the policy. They need to know where they can get a copy of it. It needs to be up to date. And for a lot of people who might be watching who might not currently have, for example, sex-based harassment, not sexual harassment, not sex discrimination, a new form that came in at the end of last year in their policy. If that's missing, that's a concern, and you might need to go and update your policy to include that. As well as having it up to date, you need to be training your employees. And at least in Victoria, where we already have the positive duty, the expectation is yearly training. That can be online for majority of your employees, but for managers and for executive type people or the key kind of leads in teams, it's the expectation, at least with the positive duty, is that training is done in person. It can be done in person every kind of year or two on that, because that is obviously quite a high expectation on business, but the expectation is definitely that you're constantly reinforcing, reminding and reiterating what that policy is.
Obviously, what will work for Westpac won't necessarily work for
No.
Williams' dry cleaning business.
Yeah.
The reality, though, is that policies and training, particularly training, do not have to be a person in a headset at the front of the room with people with notepads. Training can be in the form of toolbox talks or those kind of things. I mean, the more formal, the better, but you need to find something that works for you. Tamsin, as you say, I mean, an annual training requirement or an annual reminder or some kind of annual catch-up makes a lot of sense for these kind of things because, as we've continually talked about, the sweet spot is Christmas. The sweet spot is the Christmas party. Everyone's tired. People are getting free food, free drink, and if they haven't, asking people to recall what they were told 5 years ago, it's not going to cut it. Here's another poll question. So do you conduct pre-event briefings? So I'm talking, do you conduct, do you get everyone in and say, look, this is what we're doing, read them the riot act, or gently remind them that certain behaviour is to be avoided or certain behaviour is to be positively prohibited. How many people, because I must say, working in larger corporate environments, you're probably going to get the pre-event email telling you what's appropriate, maybe linking the policy. But I'm interested in seeing what the feedback is, and it's really 50-50 and probably leading towards no.
So what do you think? Is it necessary?
I think it's always helpful to do something. It's always helpful to do something because if you think about it, the type of event where something will go wrong, you're going to need something. You're going to need something to fall back on. And if you've got a pre-event briefing, that's something in terms of, no, we told them this, the expectation was this. And this person, when something went wrong, went so outside, so beyond. Yeah. We did everything that we could to try and make this a safe, appropriate event. But, we couldn't stop. Yeah. Whoever from doing what he or she did.
You could roll it all up though, couldn't you, with the acceptance? So to say, if you want to, click yes to coming to this awesome Christmas party, you've got to maybe do a refresher training. Yep. And have, answered a question or two to make sure that you understood the expectations of your behaviour or something. Could you do that?
I think you could. It's also a tiny bit about vibe setting.
Yeah, you don't want to ruin the vibe, I suppose.
You don't want to ruin the vibe, but I think and we've actually all been here, not in a work setting, but at least in a social setting, where something is built up and you can just tell something is being built up to the point where you think this is actually going to be either really, really fun or something's just going to go slightly off the edge. Yeah. And in a social setting, hopefully that, people have regrets and they laugh about it later. It doesn't work in a workplace setting. Doesn't that that was that got awkward or that it doesn't work because there's consequences, there's investigations, there's reputational damage, and ultimately sometimes there can be dismissals. So important to do some form of pre-event briefing to get your ducks in a row before it.
So are we all adults, Julian?
Yeah, we are, but we're in a workplace, Tamsin. We're in a workplace.
Like treating people like children, some people would say.
Yeah, you might say that, but increasingly the law, and to be fair, your employees will have expectations that people will be organised and that work will be structured in a way where people will be safe. You hear that a lot. You hear that, well, I was exposed to an unsafe environment, or this was not a safe environment, or that you should have taken steps to protect me or ensure that this didn't happen. The reality is those claims are correct. Yeah. That's what the law does, that you should do those things.
So that risk mitigation, prevention. Exactly. Not dealing with it after it happens anymore.
Exactly. Understanding that for every social event, social interaction, every joke we make, every alcoholic beverage we provide, we are taking a small risk as to what will happen. The flip side of that is that increasingly you're going to need to do something to mitigate that risk, which is fine. And to be honest, hopefully will serve to avoid some of the really quite bad cases that we're talking about. Funny though they may be, they involve people getting physically injured, mentally injured. This is not something we want in a workplace. Questions? We've got tons, so let me hit them. So Jenny asks, I often hear the advice to train all employees on a policy. What constitutes adequate training, education on a policy? Tamsin, you've covered that.
Yeah, well, it's going to vary depending on the seniority of your staff. For your kind of just run-of-the-mill employees, online training should be sufficient. It should cover everything, though. Don't miss chunks of the law. So as I said, if you haven't got your sexual harassment training or bullying policy or whatever you're kind of rolling that all up in, if that doesn't currently cover sex-based harassment, red flag, you might need to update it. So as long as it's up to date, as long as it's relatively regular. So I'd say yearly. And then for the in-person training that should be occurring with your managers or exec, if you're a bigger kind of organisation, at least every 2 years. And when the positive duty comes in, I would say at least in person.
Yep. I like this one because it sort of blurs the line of what's work. Could you advise the risk for a business if they just sponsor an end-of-year event for another association where both the company employees attend and employees from other companies? So essentially this is like a scenario where you are the, not so much the host, but you're, I guess in point of fact, promoting that your employees should go to it and providing alcohol and so forth. I mean, you can jump in, Tamsin, but I think you're at risk. Now, maybe you don't have control over certain things as to how it's precisely structured, but your employees in the course of their work are going to this thing. I mean, literally you're paying for it. Yeah. So I think you've got pretty much the same risk.
Yeah, so it's just that question of what can you do to take reasonable and proportionate measures to make sure that you've, to the extent you can, eliminated any risks that might occur at that function. Obviously, that's going to be significantly diminished compared to if you're actually hosting. But there's definitely things you could do. You know, give them cab charges, say they can Uber home, remind them of your policy before they go, let them know who they can contact if, say, something does go wrong.
Yeah, and also don't sponsor events which are obviously problematic.
Yeah.
Because if you were going to sponsor an event where, let's just say, was organised by someone who
welcomed, a pub crawl, perhaps.
Welcomed risk. Yeah, a themed pub crawl where some of the themes are a bit spicy, off colour, edge of the table, you've got a problem. So, interesting question. Right. Let me just find this one. Do employers have an obligation to pay for, and I won't give them a name check, rideshare operators home when alcohol is being served at team lunches and Christmas parties? Do you need to pay for employees to get home?
I don't think you have to, but it's a really good step that you can take to say that you took mitigation steps to prevent anything happening to that employee. So you don't have to do anything in particular, but it's all the risk profile. How much risk do you want to take on? And if you're wanting to diminish your risk a little bit, one of the things you can do is say, yes, we provided alcohol, but we provided a safe way for those people to get home, rather than just saying, you know, good luck to you after the party and having boozed them up for 3 or 4 hours with an open bar.
And think about it too. I mean, for example, if you're having an event in Sydney and you have an employee coming from my hometown, the Central Coast, you can't expect them to attend a work event that ends at 11:30 and then expect them to get on a train for 3 hours home. Goodness knows what might happen to them. Think about the particular employee's scenario, and very often, to be honest, it seems a no-brainer that you would pay for someone to get home.
Small price to pay, I would say.
Well said. It also helps them actually attend, because sometimes if they can't get in, if they can't get home, they're not going to come. Oh, one more question, I think. Maybe two. Are we liable while we pay for drinks? Does our liability stop when we stop paying for alcohol? So I think that's a big lesson from that progression of cases that we saw. The upstairs, downstairs scenario doesn't happen anymore these days, where there's seen to be a sufficient connection, and that's where you have provided alcohol for a significant period of time. Also, where you're seen to endorse or support an after party. So if you encourage people to keep kicking on, or say something that alludes to the party effectively not ending, that also might add to the fact that they'll just say, well, there's a sufficient connection between the two. Really, it's a work event that's just carried on a little bit longer. You thought it was ending at 7:30, but really it kicked on until 10:30. So whatever happened between those 3 hours is now your responsibility. I love all the unspoken things in this next question. Our founder is considering having the Christmas party at his own house. What would you suggest if there is no way to say no to this request? It would be for about 200 people.
Wow. He's a generous boss. It's 200 people at his house.
He may have a golf cart or two.
Well, don't let them go on the golf cart. Put the golf carts in the shed.
You got to do a risk assessment, don't you?
Absolutely.
The goodwill in this scenario of the boss putting up the entire stuff in the Christmas in the house of the Christmas party, it's considerable.
Yeah.
You get a lot of good vibe from doing this.
Very generous.
You take some risk.
Absolutely. I want to make clear what parts of the house are the party and what parts are kind of off limits, and that might also help you then limit the risk of anything else, spa baths, golf carts, etc., that might be on the property.
Pools is another question. I mean, Christmas parties at personal houses for 200 people, I'm going to guess there's a pool. You have to make a decision. Is it going to be appropriate for your workers to be in their swimwear using the pool in a context where they're consuming alcohol? I've seen it done. Whether it's a risk you want to take, I'm not quite sure.
I also think with a house party, there's this unset end time often, because it's we're kicking on, we're at a house party. I think if you're going to have a Christmas party there, it's good to have a really set end time, and that way, and make clear that the expectation is that staff kind of leave at a certain time. That might also help any kind of behaviour that might occur after your people who are watching and the people who are taking responsibility for giving someone a tap on the shoulder and saying you've had enough to drink, time to go home. Once they've left, you want to end the party there, I'd say.
Speaking of time to go home, we're at an end. I've had a great time, Tamsin. How can we help as your lawyers, Australian business lawyers and advisors? Well, we can review policies and procedures. There's also some training coming on the 16th and 17th of November.
Yep, that'll be done by me.
Excellent. Sexual harassment in the workplace. And the 2023, gosh, that sounds like a big number, training schedule is coming soon. We have another webcast on the 15th of November. That's contract law changes and data breaches, an incredibly topical issue.
Very.
Please register at our website. But otherwise, thank you so much for attending, Tamsin. It was an absolute pleasure.
Thanks so much, Julian. It's been lovely.